Hey folks, how's it going? It's your favorite realtor, Evan Saint-Gerard from Keller Williams Realty Landmark. Today's guest is Sergey Lysenko. Sergey is a attorney. I'm going to let Sergey introduce basically what he does. Sergey, tell the people about yourself and what you do.
Sure. Hello, everybody. My name is Sergey Lysenko. I'm an attorney. I'm a solo practitioner. I'm right now talking from my home office, and I'm working from home. I'm not a company or like a law firm. I'm one solo practitioner, but I like what I do, and we agreed to have this little presentation, Ms. Evans, which is very nice of him to do.
You don't have to call me Mr. Evans.
So
your firm basically mostly handles trademarks and business owners. And what else does that incorporate?
So it's intellectual property and primarily trademarks and copyrights, and some additional forms that's related to intellectual property, except patents. I do not do patents, and I'm trying to be very clear with that, because in order to do patent law, you need to be admitted before the patent bar. And I want to make it's very clear that a patent is not something that I'm doing. I may have some general knowledge about it and may be able to answer some very general questions. It's a form of intellectual property.
Gotcha.
But I do not, not really doing, patents.
Well, one of the reasons why I wanted to interview, because last year we all were involved in the same thing, basically with the COVID. A lot of people basically were forced basically to reevaluate where their businesses are. And a lot of people basically they had dreams of doing their own businesses, and they're like, you know what, might as well do it now. So a lot of people are realizing, hey, let's start. My actual dream is to actually do this business. Let me get that off the ground and get it running. So there's a lot of stuff that people don't know about that I wanted, maybe you can shed some light on what they should know about basically in patents and stuff like that.
Sure.
Not patents, but in that
intellectual property. Sure. So basically, I think that pretty much all of the business owners always deal with websites, promotion materials, names, brands, slogans, because the idea of business is to be able to either provide services or sell products, and have a good goodwill and customers coming back. So one way or another, we often deal with intellectual property, and intellectual property is a form of property. It's a property of valuable intangible assets. It's a product and creation of human mind. Okay. So you may have real property as property of buildings and structures. You may have personal property as property in cars, motorcycle, bike, skateboard, anything, set of furniture. It's all could be personal property. Intellectual property is something that you can understand, appreciate, but you cannot really touch it, and you cannot really feel it as a physical object. And I thought about an easy way to explain and maybe give a short hypothetical or an example how it works. So maybe it's easier to understand. Let's say we talk a patent. Patent is one of the forms of the intellectual property, and patent is either a method or a process. It's in simple words, there are rules, and if you want to have a patent, you need to go through a process. It's got to be novel. It's got to be, useful, and there's different rules. But generally speaking, patent may be a process or a method. You may have a manual or a document that describes that process or method. You can hold that document, you can read that document, you can flip the pages of that document and understand the meaning and how this process works, but you cannot read or hold or flip the process itself. And that's the difference between a physical object as a manual or a document and a intellectual property aspect as a product of human mind. So that is difference between let's say patent as a process or method and a document or a manual that describes what that process is all about. Now, let's say I decide to write a book, and I'm not a patent attorney, as I mentioned, right? So let's say I decide to write a book, and I call it, I give it a title, My Little Knowledge of Patent Law. That would be a title of my book. So the title, because I'm an honest person, the title speaks for itself right away, right? So that would be a copyright. The moment I finish writing that book, I will be the owner and author of that book, My Little Knowledge of Patent Law. However, it will have nothing to do with patents. It's not describing a process or a method. It's not describing any particular method at all. It's a book, it's a copyright. So I would be the author of this work of art, and that would be a book. Now, if I want to increase my protection, I may file a copyright implication with the US Copyright Office, and I may be able to secure a federal copyright protection, which would be great for me, right, as the author. And then let's say we have a good relationship, and I decide to give you one copy of that book to you as a gift, and you accept it and you put it on the shelf. Well, you own that physical book, and it belongs to you, and that would be a personal property of yours. Gotcha. But you would not own a copyright. I would be the owner of the copyright. Gotcha. So that's basically how, distinction between intellectual property and physical objects and other forms of property. Now, if let's say you decide to build a website and you decide to sell the copies of that book, that is something you will not be authorized to do. That could be considered as a copyright infringement. And so this is, this is the difference between physical objects and intellectual property, and the copyright and the patent. And let's say you put on that website that you decide to use, you put a name that is identical to the name I use for my business. So now we're talking about possible trademark infringement, because using a brand in commerce that is identical or confusingly similar to my name, to my brand. So these are like easy way. This is like an easy way to explain the difference between different, intellectual property kinds.
You've been doing this for how long now?
So I'm not like a normal practitioner, because even though I was admitted 2 years ago in 2019, before that I worked as a trademark paralegal for approximately 10 years for different companies in New York. So my, it's interesting, I did not practice law per se, but I worked for various very smart people who did. And I learned a lot, and I assisted them to the best of my capabilities. So now I'm trying to combine both. It's obviously it's a different when you practice law comparing to when you assist somebody who practice law. But it's a combination. I'm trying to combine it all together right now.
So I'm safe to say, basically, you enjoy what you do.
Yes.
All right. So what could you tell people about just the daily operations on something like this? What should they do first, basically, if they're thinking about getting whether it's copyright or trademark, basically, what's the first thing they need to do?
Yeah, so I would recommend to just talk to a trademark attorney and to explain what you do and what's your plans, and what the trademark you are using or are planning to use. And, the big suggestion is if you have some plans or ideas, try not to talk about it with anybody. Try to talk to a trademark attorney first. So that, if there's anything that could be protected, first you, let's say, file an intent to use trademark application and protect it, or file a copyright and secure it. And then you may be able to, it's better then start sharing your great ideas with your friends and maybe colleagues, etc., rather than do it the other way around. Because what unfortunately happens pretty often is that, in addition to good faith people, sometimes you can encounter those who may try to steal your idea.
Yeah. So your advice is talk to your legal advisor first.
Correct.
And then you can talk about the rest. All right, now I know people are going to ask the same question. Is basically, let's say that they talk to their legal professional, they advise them what to do. How long does this process take, basically, to get their trademark and to move everything forward?
Yes. So copyright. If let's say you have some creative design and you want to copyright, that's usually takes less time, because copyright office does not really examine the substance of the work of art, as long as you comply with the technical requirements. In other words, if I file copyright for a book, they may take a look, generally speaking, whether it satisfies the requirement, but not necessarily, go all over all the details. With the trademark, they do engage into a detailed examination of each and every requirement to make sure it's qualifies as, to function as a trademark, that there are no identical or confusingly similar trademarks already, on the record. And generally speaking, when you file a trademark, it takes before 3 to 4 months till it gets to examiner to just begin the examination process.
Okay.
And right now, for some, there was a backlog with the trademark office. So now, at that moment, it takes a little longer, and there is an expectation that is going to go back to the same schedule, approximately between the 3 and 4 months until it gets to the examiner. So then, after it gets to the examiner, if it's approved, it's usually published for possible oppositions, and it gives an opportunity to any third party who may be interested to file a formal opposition if they believe their rights would be infringed. If no opposition is filed, then it usually goes to the next level, and depending on the type of a trademark, then it may proceed to the next step, and eventually it leads to a trademark registration or issuance of a certificate of registration. So I'm talking very, very, very generic terms, because there's like different rules involved depending on what kind of application you file and what you do.
It really depends on what you're trying to do.
I'm really talking very general, kind of language.
I appreciate, what you're telling us. So here's the thing, basically, if anybody's interested, basically, they want to get more information, they want to have a sit-down consultation with you, how can they reach you?
My website is Lysenko, my last name, lysenkolaw.com. It's Lysenko law, law.com. And my email is lysenkolaw@optimum.net. That's my personal email.
Okay.
So that's the easiest way. And I would say the most easiest way is just to go to the website and find the contact information. So lysenkolaw.com, it's probably the easiest way to look it up. Go to that, you see the contact information. There's a phone number, there's an contact email. I'm always happy to talk. I enjoy talking about trademarks. So when people ask me questions, like this example about, I enjoy talking, giving a hypothetical and explaining how it works.
Yeah.
So, if anybody has any questions, I just like to try to do my best to explain it. And generally speaking, I think it would benefit any business owner if they use some kind of terms or slogans or names that identify them as a particular kind of business. It probably would benefit them to try to talk to a trademark attorney to see what they can possibly do with that. And then, from there, because very often what happens, you may be able to slightly alter the term that you have, and then it may be trademarkable. However, if you continue to use it the way you have it, it may be too generic or too descriptive, and there's no trademark protection. So if you do that for like 5 or 10 years without really alteration, you may be building some goodwill around generally conducting a business, but it's not necessarily going to be a intellectual property protected or trademark protected, because the term that you've been using is like too generic. So
Gotcha.
if you talk to a trademark attorney at the early stage, he or she, may advise you to slightly alter that term at the early stage, so that as time goes by, you are investing time not just into a selling product, but also investing into your brand that you're going to be able to protect. So it's so that's what I recommend to anybody who might be interested in having their own brand.
If anything, that's taught us based in the last year, people basically pivoted. They shifted basically from what they were used to doing, and they moved into other things. And a lot of people realize, you know what, I don't want to do the 9 to 5 anymore. I have my own business I can actually start. And those dreams are starting right now. So it's best to, talk to the right people who are going to point you in the right direction. So I really appreciate you doing this, taking the time out of your busy schedule to talk to the people. And for anybody who's thinking about real estate, when you make it big with your new business, you're probably going to need a home office and a new house. That's what I'm here for. You probably want to sell that house and buy a new one. You can scan my contact information right here.
Yeah.
Or you can reach me basically my cell phone, 917-975-5985.
I got your business card, and I have it right here next to me, right here.
Perfect.
So I'm not gonna forget about you. And if I have any questions about real estate, definitely I will reach to you. Yeah.
All right. So, Sergey, thank you so much for doing this. Everybody, don't forget to like, share, and subscribe to this channel. We're going to have more videos such as this. If you want more information with what Sergey does, definitely reach out to him. You'll have his contact information at the end of this video. And thank you for watching, and tell all your friends.
Thank you very much.